Hey, Gopal.
For the respondent award holder.
This court further finds that the award is reasoned, founded on the material placed before the tribunal, and does not suffer from perversity, patent illegality, or any violation of the fundamental policy of Indian law. The petitioner's attempt to challenge the award on grounds never urged before the arbitrator is impermissible within the narrow contours of Section 34. In the absence of any ground warranting interference, this court sees no reason to disturb the impugn award dated 9/2/2023. Accordingly, the present petition stands.
So grateful, Malad. Malad, just one indulgence, Malad. Pursuant to an order of the court, I had deposited the original documents with the court. If your lordship would recall in the hearing, your lordship was going through the original deeds. May I have them back, Malad? And if the file is not here, your lordship would place it for to be mentioned so that the originals could be returned. Because the original title deeds are with your lordship.
I'll pass a direction.
I'm so grateful.
The other one is
Just similar. The one is 34, other is 36.
which is dismissed.
So good.
ये डाल देना line ऐड करना.
Your Lordship, and for the award holder, there's no settlement between the parties. Kindly withdraw the matter. Your Lordship, vacate the interim order.
In terms of the settlement arrived between the parties, the award holder wishes to withdraw the present petition. The same is dismissed as withdrawn. All interim order stands vacated.
Lordship, I'm for the judgment letter. Lordship, the concerned officer couldn't come today from Darjeeling. Such short notice. I kindly pray for 1 week's time, Lordship.
We'll recall this is that emissary.
I
I'll
pray
pass
for
an
1
order.
week's time, Lordship.
I'll pass
Kindly.
an order. It's all right.
Award of 2023. Malad, only one thing before Malad passes the order. One thing only, a factual.
The
Malad,
two
error
things
that.
you have to show me.
Yes, Malad.
To show me the entire facts of the case.
Yes, Malad. Yes.
Lordship, kindly
Under-
short passover. I'll take then, Lordship.
Password for what?
So let my senior come. Let's Lordship, kindly.
Tell him to come in 15 minutes. Password. Call him in 15 minutes. By 11, we'll take it up.
Lordship, can we take at 2 p.m. Lordship?
No.
He's not well.
Sorry, madam. No. Not possible.
Milord, I am for the petition, Milord. I have sent, Milord, but they have not yet received, Milord. Day before yesterday, this was appearing, Milord. I sought for a time, Milord, for a week. So, Milord, I have sent already. Services are with me, Milord, but from the track report, Milord, they have not yet received, Milord. So, Milord, not yet received, Milord. I have sent.
Not received means no service has been done. Learned counsel for the
29 application.
29 application.
Milord.
Learned counsel for the petitioner. states that the service has still not been effected upon the respondent. States that the service has still not been effected upon the respondent. Respondent or respondents?
Respondents.
Respondents. He prays for 2 weeks to effect service upon the respondent. That this matter will listed 1 week or 2 weeks?
1 week.
1 week. That this matter will listed after 2 weeks.
Much available. Much available. Quickly.
Yes.
Lordship, I'm praying for a short Passover. Mr. Sen is on legs. Lordship.
Let him start.
I can start.
You take the notes.
You can deal with.
If we can just pass it over for 5 to 10 minutes, not much, if possible.
I can indicate the judgments. Then my
Let him
learned friends can deal with them. This is that I'm sorry. I'll just give you a copy. Please excuse me. I couldn't find a reported version. This is also from this honorable court. Section 11 application was filed. And a learned arbitrator was appointed, wrongly recording consent. It was a misunderstanding. We filed a review petition, got the consent deleted. Then, my lord, we filed a special leave petition from the order of appointment. And this is the judgment passed. This is a property in Jharkhand. Development of a property in Jharkhand. Clause, my lord, was Calcutta for arbitration. Venue of arbitration is Kolkata. Therefore, my lord, this honorable court had been approached. My lord, now kindly, my lord, see the facts at paragraph 3. I'm sorry, this is Bihar, not Jharkhand. Appellant and the respondent entered into a development agreement dated 15th June 2015 for development of a property situated at Muzaffarpur in Bihar, measuring such and such outside jurisdiction of the Calcutta High Court. Lord, please see the next page. Development agreement executed and registered in Muzaffarpur in Bihar contains an arbitration clause which is set out herein below for convenience. Now, my lord, please see the last sentence of the clause. As amended from time to time, and the sitting of the said arbitral tribunal shall be at Kolkata. Next, my lord, disputes arose, RERA proceedings, section 9, paragraph 5, my lord, section 9 filed before the learned district judge at Muzaffarpur. Then, my lord, paragraph 8. Section 11 filed in Calcutta. Paragraph 9, my lord, jurisdiction issue raised. Paragraph 10, my lord, second line, respondent has merely denied that the Calcutta High Court lacks territorial jurisdiction to entertain or decide the application under section 11(6). It is admitted that the development agreement is in respect of a property situated at Muzaffarpur in Bihar. It is also admitted that development agreement was executed and registered outside Bihar. Then, my lord, page 5, Calcutta High Court exercises jurisdiction over the place agreed upon as the seat of arbitration. And then, Lord, the proceedings. Now, my lord, please come to paragraph 22. Lord, argument made on the definition of court. Now, my lord, kindly see paragraph 23. Subject to page 10, paragraph 23. Subject to pecuniary or other limitations prescribed by any law suits for recovery of immovable property or determination of any other right to or interest in an immovable property or compensation for wrong to immovable property is to be instituted in the court within the local limits of whose jurisdiction property is situated. Certain specific suits relating to immovable property can be instituted either in the court within the limits of whose jurisdiction property is situated or in the court within the local limits of whose jurisdiction defendant carries on business, etc. Then paragraph 24 is cause of action. Then paragraph 25. In the present case, no suit could have been filed in any court over which the Calcutta High Court exercises jurisdiction, since as stated above, the suit admittedly pertains to immovable property situated at Muzaffarpur in Bihar, outside territorial jurisdiction of the Calcutta High Court. No part of the cause of action had arisen within territorial jurisdiction. The appellant, who would be in the position of a defendant in a suit, neither resides or carries on business within jurisdiction of Calcutta High Court. Of course, under section 11(6), application has to be moved in a high court irrespective of whether high court has jurisdiction to decide a suit. This is 11 and that. Now, my lord, 42 doesn't apply to 11. That's, my lord, nobody's contention. I'm omitting that part. Please see, my lord, paragraph 35. Same argument made in support of his argument that Calcutta High Court has exclusive jurisdiction to entertain and decide the application under section 11(6) filed by the respondent. Mr. Ghosh cited Indus Mobile, Hindustan Construction and BGS Soma, and argued that once a seat of arbitration is designated, the clause designating the seat of arbitration becomes an exclusive jurisdiction clause, as a result of which only the courts within whose territorial limits the seat is located would have jurisdiction, to the exclusion of all others. In Indus Mobile, this court referred to and relied upon the dictum of a constitution bench judgment of this court in Bharat Aluminium Company versus Kaiser Aluminium, and held that one seat of arbitration has been fixed that would be in the nature of an exclusive jurisdiction clause, binding parties to specific courts which alone could exercise supervisory powers over arbitration. In Bharat Aluminium, what was in issue before the constitution bench was the meaning of the expression place of arbitration in the context of section 2(2) of the Arbitration Act. Then, my lord, paragraph 37, question before the constitution bench was whether of part 1 of the act applied to arbitration where place of arbitration was outside India, as observed by the constitution bench. Section 2(2) takes place, places a threshold limit on the applicability of part 1 where place of arbitration is not in India. Constitution bench drew distinction between venue and place, and held that only if the agreement of the parties was construed to provide for seat place of arbitration in India would part 1 be applicable. Then, paragraph 39, BGS Soma was rendered in the context of section 2, subsection 2 of the Act, and applicability of part 1 to international commercial arbitration where seat of arbitration not in India. Other next judgment is also distinguished. Then paragraph 41. It is well settled that judgment is a precedent for the issue of law that is raised and decided. The judgment has to be considered in the backdrop of facts and circumstances. Words, phrases, sentence cannot be read out of context, nor is a judgment to be read and interpreted in the manner of a statute. It is only the law is interpreted, such and such. It can never be an absolute proposition that where an arbitration agreement says that the place of arbitration is Faridabad, Delhi, and proceedings under part 1 are also validly initiated in Faridabad, the court in Faridabad, notwithstanding section 42 of the Act, lose jurisdiction just because arbitration is later conducted in Delhi and award is made in Delhi. The court has perused the development agreement. The contention of the respondent in the affidavit in opposition that the parties to the arbitration agreement had agreed to submit to the jurisdiction of Calcutta High Court is not correct. The parties to the arbitration agreement only agreed that the sittings of the arbitral tribunal would be in Kolkata. Kolkata was the venue for holding the sittings of the arbitral tribunal. Then, my lord, paragraph 44 and 45, two Supreme Court judgments on this, my lord. Paragraph 46, in this case, the development agreement provided that the sittings of the arbitral tribunal would be conducted in Kolkata. As observed above, parties never agreed to submit to jurisdiction of Calcutta High Court in respect of disputes, nor did the parties agree upon Kolkata as the seat of arbitration. Kolkata was only the venue for sitting of the arbitral tribunal. Then 47 is important. It is well settled that when two or more courts have jurisdiction, parties might decide to refer all disputes to one court, and parties cannot confer jurisdiction on a court which inherently lacked jurisdiction, as argued by Mr. Sinha. This is, my lord, for the forum selection clause part of it. In this case, parties, as observed, did not agree to refer their disputes to the jurisdiction of courts and Kolkata. It was not the intention of parties that Kolkata would be the seat of arbitration. Kolkata was only intended to be venue. Accordingly, respondent had approached Muzaffarpur court, and therefore it was held, my lord, not maintainable. Two things arise, my lord. Number one, my lord, seat of arbitration, just when you say that arbitration will be held in a particular place, doesn't mean that seat of arbitration is that place. The seat venue concept, my lord, arose out of international commercial arbitrations when parties consciously choose to have, my lord, the municipal laws of a particular country, my lord, anchor the arbitration proceedings, which is why, my lord, this had come up. This is the judgment of the Supreme Court distinguishing this argument that place of arbitral sitting is different from seat of arbitration. If your lordship sees our clause, it's, my lord, arbitration to be held at Kolkata. I'll just read out the relevant phrase. I'm sorry, my lord. Kindly give me. Yes, page 52, my lord. The place of arbitration shall be at Kolkata. That's all. Page 52, my lord, of the supplementary affidavit. Clause 12.1, place of arbitration shall be Kolkata.
Yes.
Now, my lord, my learned friend cited, that's all, my lord, place of, I'll deal with the forum selection clause later. This is place of arbitration. On this, my learned friend cited BGS Soma.
No,
If your lord,
I did not say
I think you cited Indus.
Indus and
Indus is followed, my lord, substantially in BGS Soma. In fact, if your lordship, my lord, sees, show me BGS Soma.
I cited Brahmani river also.
So why do you Brahmani pellets? Look, I just read, my lord, it's look, the concept really, this is, my lord, Enercon. This is 14.5 SCC, page 1. My lord, I just read one sentence.
Yes.
It is accepted.
Which one are you reading? Sorry.
I'm sorry, my lord, I'll just read one sentence.
Which judgment?
My lord, this is actually BGS Soma, which quotes, my lord, Enercon.
BGS.
No.
I don't think so. You have handed over a copy of the BGS.
No, they haven't. You can't.
Take
You have to bring copies. Lord, I'm really sorry. They should have brought, my lord.
Give the citation.
Lord, BJ Soma is below 2020. The boy nahi hai shona. 2024 SCC 234.
2024.
2020 volume 4
4
SCC
SCC.
234.
234.
Lord, please come to Lord, I'm sorry. Just read one sentence, Lord. From paragraph 70. Yes. And in fact, this quotes Milord Enercon's judgment in paragraph 77. I'll just read Milord Enercon's Milord view. It is accepted by most of the experts in the law relating to international arbitration that in almost all the national laws, arbitrations are anchored to the seat, place, situs of arbitration. Redfern and Hunter concludes that seat of arbitration is thus intended to be its center of gravity. That's Milord the difference of seat from Milord place of arbitration. Two sentences later, it says Milord arbitrators are at liberty to hold meetings at a place which is of convenience of all concerned. And in Enercon, it also says even though venue of arbitration is fixed in London, cannot be presumed parties have intended the seat to be also London. Venue can be different from seat. Milord, some form of gravity, Milord, of the proceeding with Milord, the seat has to be indicated by the agreement. So this is Milord. No. This is the first Milord submission that place of sitting, place of arbitration shall be at Kolkata does not mean that that's the seat of arbitration. Now, if it's not the seat of arbitration, this argument of all Milord clauses of the agreement, suit for land, all of it being overwritten, Milord, doesn't hold good. For which, Milord, I am citing this Ravi Ranjan developers. Second, Milord, argument is that this is a suit for land, which is also there in Ravi Ranjan developers. If it is a suit for land, Kolkata High Court, Calcutta High Court will otherwise not have jurisdiction because its suit can only be filed where the property is situated. Clause 12 of our latest patent clearly indicates that same is section 16 to 20. If it is a suit relating in pith and substance to right, title and interest of an immovable property, it has to be filed where the property is situated and at no other place. Or Milord, if it's more than one property where one of the properties is situated. So Milord, the forum selection clause perishes. Now I'm on the forum selection clause. Milord, 12.3. I'll read it, Milord. In the event the parties cannot resolve or settle a dispute through any of the means described above, the courts having territorial jurisdiction over the said premises and the High Court at Calcutta shall have jurisdiction to entertain and determine all actions, suits and proceedings arising out of these presents between the parties. So this is a forum selection clause. Second part of my learned friend's argument. This, Milord, doesn't hold good because forum selection clause can never, Milord, override the provision, Milord, of suits for land being having to be filed in that court. Milord, I don't want to multiply authorities. This is 20, sorry, 2007, 11 SCC, page 453.
11 SCC 453.
Yes. But I'll just, after arguments, Lord, please see paragraph 15.
What your lens number?
Last, my lord, placetum H at my lord, page 10.
Yes.
Last 4 lines, and therefore it was contended before us on behalf of the appellant that the dispute related to possession of the property, that the dispute was comparable to a suit for land, and that the submission was made specifically in view of the award being passed in such and such. Then, my lord, next page. My lord, placetum B.
That's done?
My lord, this is page 11 of the print.
Yes, yes,
Placetum B.
yes.
7 lines from the top. As stated above, we do not find merit in the contention advanced on behalf of the appellant. We have examined Exhibit P1 in entirety. Apart from the above clauses of Exhibit P1, we have already quoted clauses 11, 20, and 21, by which the parties agreed that in case of disputes between the parties, the same shall be referred for arbitration to the sole arbitrator at Faridabad, and his decision shall be binding on both the parties. Under clause 21, parties agreed that Faridabad court alone should have jurisdiction in case of disputes between the parties. On our examining the terms and conditions of Exhibit P1, along with the surrounding circumstances thereto, we are of the view that Exhibit P1 was a pure development agreement. The agreement is merely an agreement whereby party agree to develop certain property for a certain consideration. Under the agreement, appellant herein continues to remain the owner. He is to apply for permission, etc., etc. My lord, I am not, my lord, reading on. Then, my lord, below placetum F, towards the end of the line, under that section, the award can be filed in the court within whose jurisdiction the property in dispute lies. Parties cannot give jurisdiction to a court under section 14 by consent if that court does not have jurisdiction. If an award refers to an immovable property, the court having jurisdiction in respect of the same will entertain an application under section 14. In order to decide as to which court has jurisdiction to entertain a petition under section 14, reference has to be made to section 2C read with 31(1). Merely because the arbitrator chooses to hold the proceedings in a place where no suit could be instituted and chooses to make an award at that place, it would not give the court of that place territorial jurisdiction to decide a matter under the Act. Lord, next page. Lord, just above placetum D. I'm sorry, my lord, just below placetum B. In order to decide jurisdiction of the court, it is necessary to decide whether the court would have jurisdiction to try a regular suit between the parties in which the relief is claimed. Then 2C lays down the forum. Application has to be moved in the court within whose jurisdiction the opposite party resides or carries on business, or within whose jurisdiction any part of the cause of action arises. No, this would not apply because in our case it's a suit for land. This part would not apply, the rest would. Same.
So, Mr. Chaudhary, if you can actually show, because here what had happened is that initially they had gone there, right?
I'm sorry, Bilal.
Initially, the first petition they had filed.
Yes, had gone there. That's my next point. So, two arguments from my learned friend. One, seat of arbitration.
Seat of arbitration.
That, my lord, Ravi Ranjan.
Ravi Ranjan.
2, forum selection clause. Answer is this judgment and Ravi Ranjan. Parties cannot give jurisdiction to a court which otherwise has no jurisdiction. Property is situated within Rajarhat Commercial Court jurisdiction. The clause is irrelevant. 3, you also understood and I also understood that only Rajarhat Commercial Court has jurisdiction. I filed a section 9 and you filed a section 37 before Rajarhat Commercial Court. So, my lord, my submissions on point 1 and point 2 are ad idem with my learned friends, my lord, understanding. And number 4, this is forum shopping, because when you challenge the principal order in section 17 before that court dismisses your section, my lord, 37. And I'm sorry, yes, 37 appeal. And now you apply for variation of that order before the learned arbitrator. Learned arbitrator refuses to vary the order. Now, instead of going to that court, you come to this court, which is, my lord, absolute case of forum shopping. So this honorable court, in my humble submission, has no jurisdiction. Now, 2 minutes on the facts.
I have not argued on the
Yeah, just take 2, just to give a flavor. And I'm not.
I wanted
He's
to
not
give a
arguing on the facts. He's
I'm just indicating what the matter is about. Why
You can
there is
also
a
do it,
section
Mr. Sen.
37.
There's no problem. You can also argue after this. I'm not
Just take 2 minutes. I am owner, he is developer. He was supposed to put up 2 buildings on my land in, my lord, a particular time. In, my lord, 3x that time, he puts up 1 building.
I have been
Now, my
abstained
lord,
from putting up
I
the other
terminate. I terminate, I filed section 9, I obtained an interim order, get it continued in section 17. That interim order prevents him from selling without paying me my share, revenue share. During the subsistence of the interim order, he goes to the learned arbitrator and says that I'll pay you directly, let me execute, I've entered into agreements for sale. What he does is, arbitrator doesn't, my lord, immediately vary the order. My lord, arrangement is that I have to be given my share for future, my lord, conveyances. In breach, he executes 5 conveyances. There's a finding in the principal order that he is in breach, that he is in contempt of order of learned arbitrator. Now, my lord, we apply for security. We say that you have sold and you have retained money, though you had to pay me my share. So now the rest you can't sell. The whole thing must be reserved for me. That is also insufficient, but yes, something I'll get. And the second part of the land should be made free. So there is an injunction on the second part of the land, and, my lord, there is an injunction on any further sale. And because of his aggravated breach, my lord, receiver has been appointed because he can't be trusted. While suffering an order of injunction, in flagrant breach he goes and signs. So, my lord, I have an application to send him to jail, my lord, under order 39 2A, my lord. And he had a section 37. His 37 is dismissed. Now, my lord, my application to enforce the order and to punish him has come up for final hearing. That's when, my lord, he goes, tries to vary the order, fails. Now, he doesn't want to go to that court because my enforcement application is there. He, my lord, comes over here and, my lord, raises these, my lord, legal issues, which are, my lord, interesting issues. This is all credit to Mr. Sen, my lord, not to his client. For a moment, my lord, we go back to reading seat and venue again. I am grateful to my learned.
Yes, Mr. Sen.
Yes. Well, I'll start with the judgment which my learned friend cited,
Yes.
the Ravi Ranjan developers.
Ravi Ranjan.
I would also be citing some coordinate bank judgments to determine how seat is determined in the context of domestic arbitration. I have already cited Indus. Indus is in the context of domestic arbitration. Nothing to do with, again, BGS Soma is also in the context of domestic arbitration. The difference is, in this judgment, kindly see what is the clause and compare it with my clause. Definitely this clause is distinguishable clause. It cannot be seat. Well, kindly see page 2 of the judgment. Clause 37 is quoted in page 2 top.
Yes.
Kindly see. This is the entire clause. Last line, sitting of the said tribunal shall be at Kolkata.
Yes.
This is the only reference to Kolkata. This is not coupled with any other clause showing the party's choice to go to Kolkata. Now, my lord, this is distinguishable because in my case, in addition to the place of arbitration, there is a clause for forum selection as well, which says that courts at Kolkata will have exclusive jurisdiction. So, my lord, the courts have held that in the context of domestic arbitration, though it is correct that only place where the arbitration sittings are being held, that by itself will not equivalent to seat. Unless there is some contrary indicia that parties agreed to go to some other forum also, that will not be referable to seat. In my case, there is a positive indicia that parties are agreeing to go to Kolkata, which is concerned with the similarity with the Indus clause. Not only similarity with the Indus clause, with the Brahmani river case also. So, my lord, here the first distinction, your lordship will kindly come to paragraph 42. So, this observation in 42 and 43 is only in the context of that line that the sittings shall be held at Faridabad. Paragraph 42 says, it can never be an absolute general proposition of law that where an arbitration agreement says that the place of arbitration is Faridabad, Delhi, proceedings are under part 1 of the act are also validly initiated in Faridabad. Court in Faridabad would, notwithstanding section 42, lose its jurisdiction just because arbitration.
Sorry, this is reported.
Yes,
In 2022, SCC Online Supreme Court 568. I should have brought that version.
Yes.
Paragraph
Give me
matches,
the
I
citation.
think.
Give the citation.
I'll just get a copy. 2022 SCC
Yes,
Online
sir,
Supreme
paragraph
Court
gulo bar koro.
568.
In the context of
Now
fact.
we are being encouraged to rely on the INSC
INSC.
version.
INSC.
Yesterday, Millard,
Oh, we are quoting also the INSC version in the.
yes, yesterday I was taken to task in day before yesterday in Supreme Court. My Justice Dotto, I said, this is SCC Online. Why do you rely on this? I said, in our court, everybody still relies on this. You may have gone, but INSC hasn't come. I don't even know how to find it from there.
It's easier.
How do you get it?
I don't know. I've never tried. This weekend's job.
Yes.
So, my lord, lordship will see 42 and 43.
Yes.
It is not my case that simply because arbitration is being conducted in Kolkata, that is why it is the seat. My contention is seat because clause 12.1 read with the further choice exercised by the parties, conferring jurisdiction also on Kolkata. So it is venue, if I say it is the original venue, read with the further choice, which makes the venue a seat. That is what BGS Soma has said. That is the test of test. Otherwise, it is simply considered a venue and place, which is not equivalent to a seat. This is the additional difference in this case with my case. Paragraph 43. The court has perused the development agreement. Contention of the respondent affidavit in opposition parties to the arbitration agreement agreed to submit to jurisdiction of Calcutta High Court is not correct, because only the sitting shall be at Kolkata. It is not a seat. This clause is not a seat. Therefore, my lord, kindly see the next part. The parties to the arbitration agreement only agreed that sittings of arbitral tribunal would be in Kolkata. Kolkata was the venue for holding the sittings of the arbitration tribunal. So, my lord, this is the first point of difference with this case. And now your lordship will compare Indus. Indus also, the clause was different. Kindly see, my lord, Indus once.
Yes. Let me, I have leave for 2. Yes.
Paragraph 2, it is quoted, my lord. Paragraph 2, your lordship will see dispute resolution mechanism. 1, 2, 3. Third paragraph, last line, such arbitration shall be conducted at Mumbai in English language. And then next page, clause 19. All disputes and disputes whatsoever arising or in connection with shall be subject to exclusive jurisdiction of the courts of Mumbai only. So this is the test which has been formulated in BGS. So I will show your lordship that how will the courts understand whether the place mentioned in the arbitration clause is simply a place for holding the arbitration or it is also a seat. This is not there in Justice Indira Banerjee's judgment, Ravi Ranjan developers. This is number 1. Now, I show your lordship, my lord. এটা দরকার নেই সব্যসাচী yes my lord, kindly take this point was considered by our court also. Several judgments are there, my lord. I just hurriedly could take out this, and this is well discussed, my lord. I'll show your lordship. Preliminary objection has been maintainability taken on the ground of lack of territorial jurisdiction. That it is argued by senior counsel that arbitration clause specifically Mumbai courts would have excluded, whereas the arbitration shall be at Kolkata. Hence, it is contended that Kolkata was chosen merely as venue, whereas seat has to be at Mumbai, thereby conferring jurisdiction on Bombay High Court to take up Section 11 application, my lord. Then your lordship will kindly come to paragraph 10, your lordship will kindly see. BGS Somata work 66, paragraph 66. A threadbare discussion was taken by the Supreme Court, but then BGS Soma has been considered to distinguish between seat and venue as well as effect of Section 42. In such perspective, it was ultimately held that Delhi was the seat of arbitration. As such, Delhi High Court had jurisdiction to take up matters pertaining to arbitration in the said case. Then, my lord, your lordship will see from paragraph 12, a close analysis of the above principles indicate that seat venue place conundrum still persists. No straitjacket formula has been evolved as yet in that regard. However, certain yardsticks for ascertaining the seat of the arbitration can be elicited from the decisions holding the field. The primary tests so derived are as follows: the language of the arbitration clause itself, intention of the parties if ascertainable, whether there is any distinction between applicable curial law and substantive law, in other words, an assessment of the subject matter of the dispute versus the subject matter of arbitration. In the present case, the arbitration clause is clause 15 of the agreement, which is set out below. Kindly see, this agreement shall be construed, interpreted, governed by laws of India. Courts of Mumbai shall have an exclusive jurisdiction in matters concerning this agreement. In the event of any dispute or difference, claim or disputes arising between the parties, then shall be referred to resolved by arbitration of sole arbitrator. Then, my lord, towards the bottom, kindly see, arbitration proceedings shall be conducted in accordance with provisions of the Arbitration Act 1990 or any amendment to the exclusion of any of the shall be held at Kolkata. Very similar to our clause. But there is a difference. Kolkata is arbitration, jurisdiction is Mumbai. This was the issue. First sentence connects the construction, interpretation, and applicable law for the agreement to courts of Mumbai, which shall have exclusive jurisdiction in all matters concerning the agreement. However, the very next part of the clause provides for arbitration in the event of any disputes or claims arising between the parties, not only regarding interpretation, meaning, and effect of the clauses of the agreement, also in respect of rights and obligations of the parties under the agreement. It is further stipulated, arbitration proceedings shall be conducted to the exclusion of all or any remedy available to either of the parties to the agreement and shall be held at Kolkata. Thus, there is existence of overlapping and apparently irreconcilable limbs of the clause. A deeper scrutiny of the agreement, however, shows that the cause of action for disputes regarding agreement can arise in several parts of India in view of the nature of the collections, which has not been restricted to physical collection, maybe online or otherwise as well, since parties have their respective offices in Kolkata and Mumbai. Thus, the parties were at liberty to choose one of the two places as the seat of arbitration. Certain features, however, can be gathered from the language of the clause itself. Although Mumbai courts have been conferred exclusive jurisdiction concerning the agreement, the arbitration proceeding has been agreed to be held in its entirety at Kolkata to the exclusion of all other remedies of the parties. There is no indication in clause 15 that the reference to Kolkata would be for one or several particular meetings only, but applies in general to the entire arbitration proceeding itself. Thus, it can be fairly construed that although exclusive jurisdiction has been generally conferred on courts of Mumbai, arbitration has been contemplated as the chosen mode of resolution to the exclusion of all or any remedies, including with those which can be instituted in courts of Mumbai as per the prior part of the clause, and is specifically designated to be held at Kolkata. Thus, a comprehensive reading of the clause itself leaves no ambiguity that there is no distinction between venue and seat of arbitration. Insofar as arbitration is concerned, the same shall be exclusively held in Kolkata, irrespective of all other remedies available to the parties. Secondly, the earlier part of the arbitration clause contemplates disputes in all matters, including construction, interpretation, etc., concerning the agreement to be governed by the laws of India. Although the expression exclusive jurisdiction has apparently been conferred on Mumbai courts, such conferment exclusively pertains to the subject matter of the dispute as opposed to that of arbitration. The moment the venue and seat of arbitration is fixed to be Kolkata, the parties themselves subject to the provisions of including 11 and 42 of the same. So, my lord, here I stand on a better footing. Not only is the arbitration clause specific to that extent that the proceedings shall be held at Kolkata, there is a further choice expressed by the parties in the same agreement that disputes arising out of the subject matter of the agreement, apart from arbitration, they have also chosen Kolkata. So Kolkata was already in their mind regarding designating the seat of arbitration. So this, my lord, this has been actually followed from the BGS Soma. But I would like to place the BGS Soma before your lordship also, my lord. Now, kindly come to paragraph 26. Thus, the third yardstick as discussed above settles the issue to the effect that curial law for arbitration proceeding will be applicable vis-a-vis Kolkata, whereas the substantive law would be of Mumbai. The tricky part, however, is that both parties are governed by laws of India, which has also been stipulated to be the governing law for the arbitration. Hence, we cannot distinguish between curial and substantive laws applicable in Mumbai and Kolkata respectively, simply because no such distinction exists. This will apply for domestic arbitrations. This third criteria will be relevant only for international arbitrations, where the curial law and the substantive law may be different. Now, my lord, kindly see paragraph 28. Ravi Ranjan developers has also been considered in this judgment. Even in the judgment of Supreme Court in Ravi Ranjan developers supra, it has been indicated that the seat of arbitration is to be gathered from the arbitration clause and the agreement containing the same. So why I say, my lord, not only 12.1 but 12.3 has also to be looked into. In Ravi Ranjan developers, there was no clause similar to 12.3. So the Supreme Court proceeded only on the premise that merely because the sitting of the arbitration shall be at Kolkata is not enough to clothe that particular place also as the seat. Now, therefore, my lord, Indus also comes to my rescue. Indus, place of arbitration is there, plus exclusive jurisdiction clause is there. Both are there with Mumbai. 40 তে কি হচ্ছে? My lord, এটা তো international problem. তোমার কাছে কপি আছে BGS সময়? Can I show your lordship the BGS Soma from the iPad?
Don't have a copy?
I have no, I'll furnish a copy.
Just read it off. Give the iPad.
I'm just taking out the paragraph.
62 থেকে আরম্ভ করো।
We should also make our code digital code now. All of you are using tabs and all.
I think so.
High time.
Yes. But not
It's the most difficult thing which I find here. Papers. Yes.
I have not, I'm not going to the earlier part, just showing your lordship first this, what is the test? Kindly see test for determination of seat. But before that, let me show your lordship the clause concerned here also. Kindly see, my lord, I'm sorry, my lord, kindly come to paragraph 3 first, whether the clause can be considered.
Yes.
Kindly see, clause 3, the longish arbitration clause, clause 67.3 is quoted.
Yes.
Then in the next page, Roman 6
Arbitration proceeding
shall be held at New Delhi / Faridabad. And the language of the arbitration proceedings, such and such. Now, in this context, my lord, the dispute had arisen, my lord. Kindly see paragraph 4, towards the middle, between August 2011 and August 2016, 71 sittings took place at New Delhi. Then the question where 34 would take place. So the point which was taken in regarding jurisdiction was that 21E court would be the court at Delhi or Assam. That was the issue, my lord. In this context, my lord, kindly come to 62. My lord, I think, my lord, it would be better I would give your lordship a compilation of these judgments, because there are some other coordinate bench judgments discussing the seat and venue. So, my lord, I want to give your lordship, my lord, all the compilation. In fact, this one is Justice Bhattacharya. I just could trace out now. There is one more of Justice Bhattacharya also, my lord. Your lordship will kindly see 62. The judgments of the
English court.
Yes, judgments of the English courts have examined the concept of juridical seat of the arbitration proceedings and have laid down several important tests in order to determine whether the seat of the arbitral proceedings has in fact been indicated in the agreement between the parties.
Now we should be quoting more Swadeshi judgments.
Yes. That is what, my lord, your lordship has probably noticed. The Solicitor General in his farewell speech of the Chief Justice of India has said that Swadeshi judgments and Indian judgments are now promulgated by the previous and the current Chief Justice. Kindly see, my lord, paragraph 63. It will thus be seen that when there is an express designation of a venue, no designation of any alternative place as seat, combined with a supranational body of rules governing the arbitration and no other significant contrary indicia. This is the test. Inexorable conclusion is that stated venue is actually the juridical seat of the arbitration proceeding. This, my lord, in my most respectful submission.
You have to also overcome, Mr. Sen, your conduct also. You had initially approached the commercial court at.
Yes, my lord, that my case is that if it is a quorum non judice, I have gone there, there cannot be any estoppel against law. I may have gone there, invoked the jurisdiction of the court. If your lordship finds.
You stated so in this petition that you had wrongly approached the commercial court at Rajarhat.
No, that is not stated. I have stated that this is the court because this is the in terms of the clause, arbitration clause read with the forum selection clause.
All this I can distinguish.
My lord.
All this I can distinguish.
No,
the facts of the case. I'm just putting it.
No, my lord, probably, my lord, on the basis of these judgments, this cannot be distinguished. I'll tell you, lordship, why, my lord.
No, under the facts of this case, to this particular.
Yes, my lord, I say, facts of the case, one proceeding has gone to Rajarhat Commercial Court. Can it be said that because the parties have gone to a wrong forum, the first your lordship will have to decide.
You're not saying anywhere in your petition it's a wrong forum. That is not your argument. Today you are making this submission. That's a wrong forum.
This is a submission on law. Whether it is a correct forum or not, this is the position which is established by the judicial precedent. Because, my lord, frankly speaking, before Indus, there was no concept of seat determining the jurisdiction of the court in a domestic arbitration. Your lordship will not find, my lord, we were completely taken aback by the judgment which came in Indus. Then it came to be followed by, this is the BGS Soma, which now lays down even in domestic. We were still trying to distinguish that by saying, as Mr. Chaudhary had tried to do in Bolko, saying that it was a concept of international arbitration. But unfortunately, my lord, all the judgments which have now come are in the context of domestic arbitration as well. So, my lord, if that is the law, my lord, my first submission, if your lordship has to distinguish, first your lordship has to come to a conclusion that it is a correct forum. Rajarhat Court was a correct forum. If it was a correct forum, then my conduct is under scrutiny. If it is a correct forum, then I have to go. I should have gone there. Then it becomes a case of forum shopping, if at all. But if I am able to persuade your lordship on the basis of these judgments to hold that Kolkata is the seat of arbitration, and Kolkata being the seat of arbitration, there is no other forum where I could have gone. Then, my lord, the argument of forum shopping, which my learned friend raised, taking a cue from your lordship, of course, that will not hold good. Forum shopping will apply only when there is a forum available in law. So, my lord, this is paragraph 63. If your lordship will see, this is the first paragraph which I am relying upon. Then kindly see paragraph 66. 962016. But this is not the way that we should do, of course.
I've given a copy.
Copy diye Well, hard copy has been.
Hard copy. Actually, this okay. Thank you.
No, whichever is convenient to your lordship.
Paragraph 62, right?
Considering the facts of BGL Soma.
Yes.
But paragraph 66, your lordship.
Yes.
This is, my lord, referring. The court then held that although the word venue is not synonymous with seat, on the facts of that case, London, though described as the venue, was really the seat of the arbitration. This was for the reason that London was a neutral place in which neither party worked for gain, in which no part of the cause of action arose. So it is not necessary that there has to be a cause of action. It was thus understood to be a neutral place in which the proceedings could be anchored. Secondly, the court stressed on the expression arbitration proceedings in clause 18.3, which the court held to be an expression which included not just one or more individual hearings, but the arbitration proceedings as a whole, culminating in the making of an award. The court held, secondly, the language in clause 18.3 refers to arbitration proceedings. That is an expression which includes not just one or more individual or particular hearings, but the arbitration proceedings as a whole, including the making of an award. In other words, the parties were anchoring the whole arbitration process in London right up to and including the making of an award. The place designated for the making of an award is a designation of seat. This is very important. Moreover, the language in 18.3 does not refer to the venue of all hearings taking place in London. Clause 18.3 instead provides that the venue of the arbitration proceedings shall be London. This again suggests that the parties intended to anchor the arbitration proceedings to and in London rather than simply physically locating the arbitration hearings in London. Indeed, in a case where evidence might need to be taken or perhaps more likely inspected in India, it would make no commercial sense to construe the provision as mandating all hearings to take place in a physical place as opposed to anchoring the arbitral process to and in a designated place. All agreements, including an arbitration agreement, should be construed to accord with business common sense. In my view, there is no business common sense to construe the arbitration agreement in a manner which would simply deprive the arbitrators of an important discretion that they possess to hear evidence in a convenient geographical location. Then, my lord, kindly come to paragraph 67. The court then held that the reference to the Indian Arbitration Act would not make London the venue and India the seat of arbitral process for several reasons, including the fact that in earlier agreements between the same parties, seat of arbitral proceedings was India, which was changed by this agreement to London. The explanation for this change, this is not relevant for our purpose. 80. Kindly come to paragraph 84. Let's deal with something more Indian.
Yes.
Yes. Then, let's kindly see 83. 83 Brahmani river pellets is considered, which I had cited.
Yes.
Recently, in Brahmani river pellets, this court in domestic arbitration considered clause 18, which was the arbitration agreement between the parties and which stated that arbitration shall be under Indian and Arbitration Act 1996 and the venue of arbitration shall be Bhubaneswar. After citing several judgments of this court, then referring to Indus Mobile, the court held. I am not placing the paragraph 18. Now, 84. On a conspectus of the aforesaid judgments, it may be concluded that whenever there is the designation of a place of arbitration in an arbitration clause as being the venue of the arbitration proceedings, well, this is the line.
Yes.
The expression arbitration proceedings would make it clear that venue is really the seat of the arbitral proceedings, as the aforesaid expression does not include just one or more individual or particular hearing, but the arbitration proceedings as a whole, including the making of an award at that place. This language has to be contrasted with language such as tribunals are to meet, have witnesses, experts of the parties, where only hearings are to be take place in the venue, which may lead to the conclusion, other things being equal, that the venue so stated is not the seat of arbitral proceedings, but only a convenient place of meeting. This is the expression, if there is no contrary indicia. What do you mean by there is no contrary indicia? No contrary indicia as to this, holding particular hearings at particular places. Further, the fact that arbitration proceedings shall be held at a particular venue would also indicate that parties intended to anchor arbitral proceedings to a particular place, signifying thereby that place is the seat of the arbitral proceedings. This, coupled with there being no other significant contrary indicia that the stated venue is merely a venue and not the seat of the arbitral proceedings, would then conclusively show that a clause designates a seat of the arbitral proceedings. In an international context, if a supranational body of rules is to govern the arbitration, this would be further be an indicia that the venue so stated would be the seat of the arbitration. In a national context, this would be replaced by the Arbitration Act 1996 as applying to the stated venue, which then becomes the seat for the purpose of arbitration. Well, kindly come to paragraph 100 thereafter. Kindly come to, my lord, before that, 97. Coming to the impugned judgment in the present appeals, it is clear that the reasoning followed stems from the subject matter test that flows from the definition of court in 21E1 of the Act. According to the impugned judgment, since the agreement was executed at Faridabad, part of cause of action would arise at Faridabad, clothing for Faridabad courts with jurisdiction for the purpose of filing 34. Second part of the reasoning is that Faridabad is the place where request for reference to arbitration was received, as a result of which part of the cause of action arose in Faridabad, which ousts the jurisdiction in which no part of the cause of action. We have extracted arbitration agreement in the present case as contained in clause 67.3 in paragraph 3. As per the agreement, in case a dispute was to arise with a foreign contractor, clause 67.32 would apply. Under this subclause, a dispute which would amount to an international in the meaning of 21F would have to be finally settled in accordance with the rules of the Arbitration Act and the ancestral arbitral rules. In case of any conflict, Arbitration Act 1996 is to prevail. As an award made under is considered domestic award under section 2.7, notwithstanding the fact it is an arbitration award in an international commercial arbitration. Then your lordship will kindly see, applying the Shashwa principle delineated above, it is clear that if the dispute was with the foreign contractor under 67.3, the fact that arbitration proceedings shall be held at New Delhi, Faridabad, India, in subclause 6 of 67 would amount to designation of either of these places as a seat of arbitration as a supranational body of law is to be applied, namely ancestral rules, in conjunction with the Arbitration Act. As such, arbitration would be an international commercial arbitration which would be decided in India. Arbitration 96 Act is to apply as well. There being no contrary indication in such a situation, either New Delhi or Faridabad, India is a designated seat under the agreement. Therefore, for the parties to choose as to which of the places arbitration is finally to be held.
Yes.
Now, my lord, let us come to 99. Given the fact that if there were a dispute between NHPC Limited and foreign contractors, 67.36 would have to be read as a clause designating the seat of arbitration. The same must follow even when subclause 6 is to be read with subclause 1 of 67.3, where the dispute between NHPC would be with an Indian contractor. Arbitration clause in the present case states arbitration proceedings shall be held at Faridabad, India, signifying that all hearings, including making of award, are to be take place at one of the stated places. Negatively speaking, clause does not state that venue is so that some or all of the hearings take place at the venue. Neither does it use language such as the tribunal may meet or may hear witness, experts or parties. Expression shall be held indicates that the venue is really the seat of the arbitration proceedings. Dispute is to be settled in accordance with the Arbitration Act 96, which therefore applies a national body of rules to the arbitration that is to be held either at New Delhi or Faridabad, given the fact that the present arbitration would be Indian and not international. It is therefore clear that in such a scenario, New Delhi stroke Faridabad, India has been designated as the seat of the arbitration proceedings. However, the fact that in all the three appeals before us, the proceedings were finally held at New Delhi, awards were signed in New Delhi and not Faridabad, would lead to the conclusion that both parties chose New Delhi as the seat of arbitration under 20 subsection 1. That being the case, both parties have therefore chosen that courts at New Delhi alone would have exclusive jurisdiction over the arbitral proceedings. There is no question of going to Rajarhat in view of 20.1. Therefore, the fact that a part of the cause of action may have arisen at Faridabad would not be relevant. Even if property is situated at Rajarhat, it will not be a relevant factor to give Rajarhat court the choice of the forum. Once, my lord, Kolkata is designated as a seat and there is no contrary indicia. And my lord, just Ravi Ranjan developers, as I told your lordship, my lord, this is only on this aspect of the matter. The arbitration clause, my lord, kindly see, sitting of the tribunal shall be at Kolkata. There's a difference. It's the place of the arbitration at Kolkata. So this is not always, cannot be said it is equivalent to seat.
Right.
But insofar as the maintainability point is concerned, Lord, these are my submissions. Oh, but I just yesterday I had submitted the judgment of Justice Sarkar in relation to section 42. I don't know whether my learned friend is pressing that point still or not. Copy down.
Lakshmi Prasad Agrawal.
Yes, yes, Manoj. আমাকে যে হার্ড কপি ছিল ওই ব্যাগটার ভেতরে কাইন্ডলি সি প্যারাগ্রাফ 2 এটা কালকে দিয়েছে না APOT 15 of 2025 is an appeal under 37(2) of the Arbitration Act. Appellant is aggrieved by an interim order passed under section 17 of the act by a learned arbitrator sitting at Delhi on 18th November 2024. Then order is quoted thereafter. Kindly come to paragraph 3. Order was challenged on the ground of lack of jurisdiction of the learned arbitrator and the unilateral appointment. Arbitral proceeding is already pending before a learned arbitrator at Mumbai. Appellant was never informed of change of venue from Mumbai to Delhi as also change of an arbitrator. Initially, respondent initially appointed, unilaterally appointed Mr. Rajendra such and such Agrawal as an arbitrator. Delhi High Court terminated the mandate, appointed Neeta Jain as a substitute arbitrator. Then, my lord, paragraph 4, appellant had filed a suit before the City Civil Court and ad interim injunction was passed. In view of the order passed by the learned City Civil Court, the arbitrator deferred the proceeding. Appellant was surprised to find out that the respondent had initiated a proceeding before the arbitrator at Delhi without any further reference to the earlier proceeding and without any intimation to the appellant. Then, my lord, we had raised an objection before the arbitrator. Without deciding on such questions, arbitrator passed the impugned order ex parte. Order is challenged before this court on the ground that the learned arbitrator could not have continued with the proceeding on the ground of unilateral appointment. Also because the arbitration proceeding was pending before Srimati Neeta Jain, who was appointed as substitute arbitrator by Bombay High Court. Then now kindly come to paragraph 6. This court finds that entire cause of action arose within the ordinary original jurisdiction of this court. The bank account which has been frozen is within the ordinary original jurisdiction of this court. Despite several opportunities and intimation to the respondent, it failed to appear. Respondent also continues business within the original jurisdiction of this court. It appears the respondent is not interested to contest. Subject matter of the arbitration is the loan which was availed by the appellant, and the entire transaction, according to appellant, pleaded and supported, took place within the original jurisdiction of this court. Scope of interference by this court under section 37(2) is quoted. Then, my lord, paragraph 7. This is, my lord, the definition of court under 2(1)(e). Kindly turns the next page. Page 6 top, your lordship will get an appeal was filed in Mumbai from an interim order passed by the arbitrator who was unilaterally appointed. Previous appeal was in Mumbai. The Bombay High Court passed an order. Law is well settled that provisions of section 42 of the Act will not apply to an appeal under 37(2) of the Act. Then, my lord, Pandey and Company versus State of Bihar has been relied upon. Moreover, the respondent waived venue clause by approaching arbitrator at Delhi. Proceedings continued in Delhi. So, my lord, two things which come from here. There was an Mumbai court which exercised jurisdiction of an earlier 37(2) appeal, arising out of the same agreement, same proceeding. Calcutta High Court found that their jurisdiction is Calcutta High Court is 2(1)(e) court. Therefore, without applying and invoking 42, which does not apply, Calcutta High Court has exercised jurisdiction in respect of the second appeal. And here, my lord, the point of forum shopping could have come. It was nobody's case that Mumbai court did not have jurisdiction. Therefore, the second appeal ought to have gone to Mumbai as a part of the forum, already chosen by the parties earlier. So, my lord, here, my lord, I say, my lord, that first, as I've argued, my lord, principle of 42 will not apply. And secondly, I have shown from these judgments, my lord, and the language of the arbitration clause, it is not a place of sitting of the arbitration, which the parties have chosen. It is the seat of arbitration. And therefore, my lord, the Rajarhat court is a court which is quorum non juris.
My lord, I'll give a 1 minute reply, Lordship. Lord, I agree with what has fallen from my learned senior friend and what is the principle in BGS Soma, my lord. We cannot go beyond what has been laid, that is the law. Now, my lord, principally, my lord, it's very simple, my lord, I have figured out, my lord, is a very simple concept about place and seat. Where, my lord, the seat is not separately designated, the place becomes the seat. Seat from where, my lord, the juridical seat of the arbitration is decided. The courts having jurisdiction. Why, my lord? Because party autonomy is given preference. That is how the law has changed. My lord, firstly, the law was section 16 to 20 of CPC will apply. Now the law has changed to section 20 of Arbitration Act will apply. But there is, my lord, a fundamental exception to both of this, which is not covered by BGS Soma. Is, my lord, when we see section 21E, my lord, it says court otherwise having jurisdiction. And, my lord, here, a court not having jurisdiction in a suit for land, my lord, cannot entertain or cannot be a court within the meaning of 21E. This is, my lord, my first submission. Second, my lord, is BGS Soma does not contemplate a situation where it is neither a domestic arbitration, nor is it, my lord, a situation where there's an immovable property situated, a suit for land is situated. So, my lord, this is wholly distinguishable on that. It is a fact that the arbitration clause in this proceeding, my lord, says Kolkata, the place of arbitration is Kolkata. If it were, my lord, that disputes are emanating out of a mere work contract, this would apply, my lord. BGS Soma would squarely apply. But
So
when the development...
Only distinguishing factor which you're trying to say is the suit for land.
Yes, my lord. My lord, which is also recognized, my lord, by the letters patent. It is a chartered high court. They have... I'm sorry, my lord.
Yes, yes.
Yes, my lord. So, my lord, and Ravinder, my lord, Ravi Ranjan, my lord, that is also contemplating, rather has distinguished these judgments on the ground that an immovable property is situated. My lord, the language of section 21E is very clear. What is the arbitration act? That
it is the court
my
of
lord,
officials.
having jurisdiction, we cannot go beyond. My lord, it is literal translation. Place, seat, venue, these are not there in the Arbitration Act. All of this, my lord, has come, my lord, the courts have interpreted it. We've given interpretation to give effect to the Arbitration Act. But what is there in the book, my lord, that has to be given primacy, my lord. That is the golden rule of interpretation. And I'm going by the simple interpretation that court having jurisdiction. And my lord, for section 42 applying to section 37, my lord, even Ravi Ranjan has a paragraph saying that, my lord, it's a subsequent judgment, my lord. It says that 42 applies to everything. I will not, my lord, harp on that argument. Even though, my lord, they have preferred their own section 37, they have not objected to the section 9, which was filed by me. There is a specific jurisdiction clause that I have raised in section 9, to which they have not raised an objection. Lord, I shall leave that to your lordship. The SB Sinha judgment, my lord, can be distinguished on those grounds, but I will not take my argument into that. Whether Kolkata will be a place or a seat, all of these arguments under BGS Soma would apply unless, my lord, this were a suit for land. And, my lord, I have relied upon, my lord, series of judgments, my lord, from the Supreme Court, Calcutta High Court, that a development agreement, my lord, where parties, the rights of the parties emanate to the title and possession of the land. The dispute is concerning the land, my lord. It is a suit for land. And, my lord, with all due respect, my lord, this issue has not, my lord, I believe, my lord, the onus has not been discharged, my lord. Because with everything else, my lord, I concur. BGS Soma can't be touched, but it is not applicable to me, lordship. And therefore, this is just a venue. This is just a venue. We need not have indicated otherwise.
Yes.
But I have answered the suit for land point. 12.3 is not only 12.3 is an answer.
And 12.3
But the Indus, which is laying down the law, which says that the neutral venue may not, the principles of CPC suit for land will not apply if the parties have chosen the venue.
That has been
But
distinguished.
the
in Ravi
language is the
It's a subsequent judgment.
neutral venue may not in the classical sense have jurisdiction. That is, no part of the cause of action may have arisen at the neutral venue, neither would any provisions of 16 to 21 be attracted. Suit for land is 16 to 21,
And
so
it is
where
an
the property is
exception.
situated.
Heard.
Malad, if Lordship requires Malad, a compilation or Malad, a note, Malad, we will provide it, Malad, as your Lordship.
And you will take some time. When will you give it?
Malad, next week,
Lordship wants a note or only the
Malad,
compilation?
whatever Lordship.
Give a note with compilation.
Note with Malad, 7 days, Malad, we'll have it prepared.
No, why 7
3 days.
Yes, Malad, Monday, Malad. Monday to Tuesday.
Monday or latest Tuesday.
Tuesday,
Tuesday.
Malad, we'll
But
have
thereafter, Malad, we go on to the merit.
Yes.
it. Grateful.
Straight on.
Malad, may I take your Lordship's?
Learned counsel for the parties are at liberty to file a brief 3-page note along with all the relevant judgment they wish to decide on the issue of maintainability of the present petition. Let the same be done within a period of 3 days by Tuesday. Tuesday date there. Okay. Heard, reserved.
Oblige.
एक बजे कटों को जाना है
Tuesday দিতে হবে।
দিতে হবে, থাকবে না তো লিস্ট।
Well, will it appear as to be mentioned or we just hand
No,
over?
just hand over. Just hand it over. Yes, sir.
তারপরে তো আর কোনো ডেট ফিক্স করার দরকার নেই।
No, judgment.
কি করবে মাথা? বলে দিই।
The next matter, my lord, can be taken up on Monday, my lord. This is at 34, my lord. I was arguing, my lord. I will get stuck, my lord.
This
This
is
is
that.
a truth matter.
Damages
Damages claim
to
for
be
damages,
calculated.
which is.
Yes.
Lord, I
So-
appear for the Jute
Can we
Corporation.
come back on Monday, my lord?
Lord, may I plead for Wednesday in that case, my lord?
No, let's finish it. Why do you want to push it? Let him argue. Let him start. Then at least we can finish all these
Lord,
matters.
Monday is the monthly list. That is why.
ও আচ্ছা আচ্ছা Wednesday month list চলে যাবে তখন।
Yes, my lord. Monthly list, it can. If it retains its position, I have no problem, my lord. Otherwise, it might go.
No, this has to retain its position. This has to retain. We have heard.
Yes.
Started hearing it. Let's finish it off. Monday.
Monthly.
Monday we'll have it.
Yes.
Great,
Oblige.
my lord.
I appear for the award holder.
Yes.
Lordship, my senior actually got a family emergency. His brother got demise, Lordship. Can we
But
please,
this
I
is
pray
no
that
way.
this matter be
These
kept
are all
on Monday.
excuses, madam. These are all
Lordship, it's not
excuses.
an excuse, Lordship.
These are all excuses, nothing else.
Lordship,
Your
it's
officer
not.
is also not here. We'll pass an
Lordship.
order. The manner in which you have dealt with this, it just shows
Yes,
what you want to do.
yes. Malord, we kindly have the award. Malord, I'll just give a brief overview as to what has happened. It's an MSME award. Malord, page 8, the award starts. Page 8 of GA1. Malord, I'll place everything from GA1. That will be
J1
easier, Malord.
you understand the kind of public money 42 lakhs converting into 24 crores.
No.
Who pays it? Government. Whose money? Taxpayers. Just because you are sleeping over it. 42 lakhs to 24 crores.
That's Lordship.
Malord,
And still you are taking date, your officers are not appearing in the court. Is it a joke?
Lordship, they have given us a formal instruction as well, Lordship.
What formal instructions they have given you that they can't pay?
Lordship. that
What have you
they-
done in this entire case? What formal instruction they have given you, madam?
Lordship, they have given us a letter that they will appear next week, Lordship. Kindly.
They will appear and do what? They will appear. For sure they will appear. After I'll issue arrest warrant, they will appear. I'll get them arrested and they will appear. I will issue arrest warrant against him. Yes.
I'll just indicate the brief overview. Page 8 onwards is the award. Page 8, Muller will find as the award passed by the MSME Council 17 January 2023. Muller, this relates to work orders placed upon my client by the Gorkha Territorial Administration, which is a government entity. Muller will find paragraph 6 if Muller kindly has. Paragraph 5, Muller will find we had participated in an NIT for making supplies of GI pipes, valves, GI special with reference to so-and-so. Work orders were allotted. Kindly note the date 2014. Paragraph 6. All the work orders are of 2014. Thereafter, we complete the work. Muller will kindly turn over the page. I'm just indicating the brief facts as stated in the award itself. On receipt of the order, supplier unit, that is my client, supplied the goods amounting to 2479 so-and-so.
24 crores, 37 lakhs.
Yes, 24 crores, 37 lakhs. We had supplied 79 lakhs, Muller. Yes, I was paid 24 crores, 37 lakhs. Now, one thing I must note, Muller.
The balance was 42 lakhs, 41,920.
Yes, Muller, one more thing, may I just indicate? Last occasion, Muller, in Muller's order has indicated 42 lakhs is the principal outstanding. Undoubtedly, that is the principal outstanding of the unpaid cost of the goods. But Muller, under the MSME Act, statutorily, I am entitled to payment within 45 days of my raising invoice, or else I am entitled to delayed payment interest. That's a statutory mandate because I'm an MSME unit. Muller, total, if it comes to 42 lakhs as on date of passing of the award, 42 was the outstanding price of goods. Apart from that, 11 crores was the principal outstanding on account of delayed payment interest. That is also statutorily mandated. I'm just indicating that, Muller, because last occasion Muller was perhaps has recorded that 42 is the total outstanding. It's actually 11 crores, which was the delayed payment interest till the date of award, along with 42 lakhs. So about 13 crores and all, or rather 12 crores and all. Now, Muller, may I just read on? Buy unit was paid so and so. Buy unit deducted TDS amount but did not deposit TDS on 3 payments of rupees so and so and so and so. Therefore, supply unit did not get refund of TDS amount of 5 lakh 40.
Your total claim was 42 lakhs.
42 lakhs is the price.
With the interest, it went up to 11 crores.
Interest was prior. Muller, invoices were raised from time to time from 2014 onwards.
Correct.
So the delayed payment on each of those invoices, that as on date,
that accumulated to 13 crores.
Yes.
And then subsequently they have not paid,
24.
so that has accumulated to 24 crores.
24 crores.
Very nice.
Exactly. That's in sum and substance, that's my case. Muller. We'll see that paragraph 12, there's a allegation that was made on the last occasion that they had not appeared. There were notices served. Thereafter, every meeting, Muller, they have failed to appear. And they've also admitted from the bar today that they had failed to appear. Muller, we'll see thereafter the submissions are noted. I'm not on that, Muller. Will kindly see. Procedure followed at page 10. It's a procedure followed that's towards the bottom of page 10. The specific rules that are provided for in the West Bengal MSME Council rules, those were specifically followed. Buy unit did not submit a written response at all. There's no dispute at all raised before the arbitrator. And then directly, Muller, will come to page 11. The arbitrator's findings are there, or the arbitral tribunal's findings are there. Statement of fact, supply unit. This is undisputed. Again, it's a reiteration. And Muller, what has happened between the initiation of arbitration in 2021 and till 2023 is all recorded. It culminates finally in paragraph page 15. Page 15 are the bullet point orders that are passed. Muller, will kindly see. I'll just read this, Muller. Will kindly indulge me. Whereas from the above facts on record, it has been established that the petitioner supplied the materials as per the order of the respondent buyer unit. Whereas perusing the findings of the case, the claim of the petitioner is found true and logical. The buyer unit is liable to pay the total principal outstanding of 42 lakhs so and so, plus interest thereon at 3 times the bank rate compounded with monthly rest to the supplier unit under section 16 of the MSME Act so and so. Thereafter, Muller, this is the interest component. Interest will be calculated on 42 lakhs on each pending bill. The interest will be calculated after 45 days from the raising of each invoice. And that's as per the MSME Act till realization of the due amount. As regards the claim on interest on delayed release of the amount of 2437. 24.37 was the amount that was paid to me, but that was delayed. The supplier unit is entitled for interest for delayed releasing of the same, which will be calculated after 45 days from the appointed date, i.e. the date of actual delivery till receipt of the respective payments. The supplier unit is directed to submit their claim on interest unit to the buyer unit, and the due amount as per the directions of the above para duly quantified and certified by a chartered accountant with a claim of the principal amount of 42 lakhs. Thus, the award amount comprises principal amount and interest accrued thereof. The buyer unit is directed to pay within 30 days, so and so. We communicate this thereafter. They don't respond. In my execution case, I have also provided the tabulation as to the total amount that is due and payable. They don't pay, they don't respond. They file a section 34 application, which is finally dismissed. Well, we'll find, I'll just indicate the chartered accountant certificate is there, page 16. I'm not taking Malad through the entire thing. Page 16 to 18, Malad. The entire tabulation is there for each and every element of the claim awarded. Malad, I'll just now refer Malad to page 22, which I had placed on the last occasion. They had filed a section 34 application under section 18 and 19 of the MSME Act. Malad, they were required to make 75% pre-deposit. MSME Act is. It was required to make pre-deposit of 75%. They failed to do so, and on that score, Malad, the section 34 was dismissed. They have filed subsequently a restoration application, but the restoration won't lie because they're still, till now, they are not willing to make the mandatory pre-deposit as per the mandate of the statute. Malad, page 22, I'll just record the submission. Malad, I'll just read out. Malad, this is an order of 22nd July 2025, second paragraph. Mr. Subba, that is my learned friend's senior, submits for the respondent does not have the authority to make payment beyond rupees 1 crore. The financial limit of the GTA extends to rupees only 1 crore. As such, the 75% sum could not be deposited. The application under section 34 of the Arbitration Act was dismissed on account of non-deposit of the amount mandated by law. He submits that he cannot, that payments cannot be made because of discharge and satisfaction of the award would also involve dealing with cash beyond 1 crore. GTA has written to the state government. This Malad, last occasion they had produced that letter. It's not been supplied to us. They had written around July 2025. Award 2023, section 34 dismissed 2024. They write in July 2025 for sanction. Under such circumstances, having made out of prima facie case, execution of the award deserves to be secured. Thereafter, Malad, an attachment order is passed. I thereafter write to the bank after this order. I communicate the order to the bank. I'll just indicate the response of the bank. Malad, page 29, Malad will find the response of the Central Bank of India, which is the respondent's banker. Malad will find the total amount that is indicated lying in the accounts of the respondent is, I can indicate the exact amount, Malad, 13 crores 29 lakhs 6,665 is the total amount if we add up all these figures. So 18 crores is still outstanding. Now, my prayer before Malad in this application, and why I had to take out this application, is this award today stands final and executable. I have calculated the interest that has accrued on the award even after taking 13 crores and odd to be the principal, delayed payment interest plus principal price of goods. I am seeking Malad Malad will kindly take my notice of motion once. Oh, master summons, I'm sorry. Master summons. Malad will master summons at affidavit in support. Okay. But prayer A, Malad, 18 crores was directed to be attached. Prayer A, Malad, is in continuation of the prior order passed by Honorable Justice Malad, the learned coordinate bench.
This is
Malad, has prayer A?
para 7.
Yes, Malad. As indicated in para 7, in paragraph 7 of the affidavit in support of master summons.
Affidavit in support.
Affidavit in support of master summons.
Affidavit of asset देखा.
affidavit of assets. From our
affidavit of asset.
Huh? Affidavit of assets. Affidavit of assets, they don't disclose the entire facts, but we have taken. You have the affidavit of assets?
Yeah.
Okay. We'll see their bank accounts are indicated. Page 2 onwards,
Yes.
they're the bank accounts. State Bank of India, we had no knowledge of. Then, we'll see paltry sums. Only 99 lakhs apparently are outstanding, are lying in that account. Axis Bank, page 3, there are also 19 lakhs about is lying outstanding or other maintained in that account. Thereafter, we'll kindly see they've gone department by department. So, these assets which they have identified, they can be attached, but all of them seem to have paltry sums. From our inquiries, if takes page 3 of my application, GA1, my affidavit in support of the master summons, we have found several other bank accounts at paragraph 7 and 8. Paragraph 8, will kindly have.
Yes.
These additional bank accounts which we have been able to cull out. This is of the Gorkha Territorial Administration itself. It's of the Office of the Executive Engineer. The award is binding on the administration as a whole. Therefore, I am praying, and to my client's knowledge at least, substantial sums are lying in these bank accounts. Will kindly extend the order of attachment also to these bank accounts. And my final prayer, which I have made, will kindly consider, and I'll indicate why. Prayer B of my master summons, last submission, prayer B of my master summons.
These are already attached.
These are not attached, in the order, we'll see the account numbers are different. I'll just indicate. These are not the same, will kindly take page 23 of my application, read with page 3. These are different accounts which we have been able to ascertain. These are additional accounts. These are not attached. So I am seeking an attachment as to these additional accounts as well. And prayer B of my master summons, I'm praying for release at least. I understand, it's really, I understand it's difficult to even comprehend how a delay on the part of a respondent government amounts to such a huge claim being accrued only on account of laches, only on account of laches and pure negligence. But at least ad hoc, because my client, I pleaded specifically, my client is in dire financial states. Even if an ad hoc amount, will kindly direct
No, you
to
are
be released.
all these are hand in glove issues. So it's not so simple, but yes.
At least an ad hoc amount, I'm humbly praying, the entire awarded sum, is due and payable to me. But at least for the time being, let an ad hoc amount be made paid to me. And we have all the documents to show that my clients' accounts have gone into their distressed accounts and now even non-performing assets. They've been declared to be non-performing assets under the RBI guidelines. So we're facing imminent threat. That's my prayer, additional attachment as to these additional accounts and release. I appreciate at least an ad hoc amount.
Take down. The award holder has instituted the present execution petition seeking enforcement of the award dated 17/1/2023, passed by the West Bengal State Micro and Small Enterprise Facilitation Council in arbitration case number 106 of 2021, MS Mahindra Tubes Limited versus Executive Director, PHE Department, GTA, PHE, all capital. Here. Yeah, sir. Wait.
GTA is
The-
Gorkha Territorial Administration. I provided that.
GTA bracket में कर देना Gorkha Territorial Administration. The award holder, comma, and MSME unit, comma, supplied GI pipes, comma, valves, comma, and GI special GI pipes,
Yes, Malad.
pipes and GI specials with
Special valve.
with GI specials to the award holder pursuant to various allotment orders issued under tender notice number NIT number 02/PHE dated 29/2013, full stop. Between February 2014 and July 2015, comma, the award holder supplied materials valued at rupees 24,37,035 lakhs. ये यहाँ पे ले लो ये figure, ठीक है? हाँ, ये ये वाला figure. Receipt of the order supplied goods amounting to 24,79,77,419.01. Full stop. Against this, comma, the award debtor made a payment of rupees 24 crores 37 lakhs 35,427.00. Full stop. Leaving an outstanding, नहीं, full stop नहीं करना, comma, leaving an outstanding of rupees 42, 41, 922, 42 lakhs 41,922.01. नहीं, 42 lakhs 41,922.01. हाँ, 922 कर दो बस, 922 towards unpaid supplies. Unpaid supplies. Unpaid dues कर दो, unpaid dues. Full stop. Owing to non-payment of the said dues, comma, the award holder invoked the jurisdiction of the Facilitation Council under Section 18 of the MSMED Act, right?
MSMED Act.
MSMED
Should I
Act.
read out, Malad, the entire?
Yes, what is it?
The Micro, Small and Medium Enterprises Development Act 2006.
2006. Full stop. The award debtor remained absent both during the conciliation proceedings under Section 18(2) and as well as during the ensuing arbitration. That's para 4, right?
Yes, Malad.
Ensuing arbitration. Full stop. Consequently, comma, the council proceeded ex parte
Malad.
and, comma, by an award dated 17/1/2023, passed under Section 31 of the under Section 31 of the Arbitration and Conciliation Act 1996, directed payment of rupees.
Directed payment of the total principal outstanding
40,
and also 42 along with also Malad delayed payment. That was in a statement.
42,36,863, right?
Yes, Malad. Along with delayed payment interest.
42 lakhs 36,863 along with interest at 3 times the RBI rate with monthly compounding, comma, in terms of Section 16 of the MSMED Act. Full stop. The award debtor thereafter filed. Where is that?
Section 34 application. Malad.
Yeah,
That's a part of my
file.
execution case, Malad.
No, where's the AP?
The AP is not listed here, Malad.
No, but what is the number of the AP?
Yes, yes. AP 763 of 2023, page 37 of my main execution application. Main execution application, Malad, you'll find that.
Page
37, Malad.
The AP, the award debtor thereafter filed AP number 763 of 2023 before this court challenging the ex parte award while the award holder instituted the present execution proceedings, full stop. The award holder also filed AP 776 of 2023 for staying the implementation of the said ex parte award, full stop. By order dated 18/12/2023 passed in AP number 776 of 2023, this court disposed of the award debtor's application under section 36(2) of the Arbitration and Conciliation Act 1996. Full stop. The court held that the statutory precondition contained in section 19 of the MSMED Act was mandatorily attracted. The full stop. The order records that the principal amount and the interest awarded cumulatively amounted to approximately 17 crores, right? 17 crores, 74 lakhs, 89,090. Full stop. Accordingly, this court stayed the operation of the award, subject to the award debtor securing 75% of the awarded amount, i.e. rupees 13 crores 31 lakh 16,818. Bracket में करना 75% by bank guarantee, 25% by cash deposit, bracket close, within 5 weeks from the date of the said order, full stop. The award debtor failed to comply with the aforesaid direction and did not secure the 75% awarded amount within the stipulated period by this court. Within the period stipulated by this court. Within the period stipulated by this court. Full stop. AP 763 of 2023 thereafter came up for consideration on 16/4/2024. Full stop. None appeared on behalf of the award debtor and the petition was dismissed for default. That's the order which you have given.
Yes.
Full stop.
No, the order.
No steps have been taken till date.
Yes.
Sorry.
Well, the order of Justice Shortcut, 20, that records the dismissal. Dismissal at
yes. No steps have been taken till date for restoration of the said petition.
Well, they have filed a restoration application. I must say, they filed it, never moved it.
All right.
Never moved it.
All right. Learned counsel for the respondent states that they had filed for the restoration of the petition, but the same has not been pursued. Full stop. Consequently, the award debtor's challenge to the award dated 17/1/2023 has effectively come to an end. Full stop. The award holder subsequently filed GA. This GA what?
GA1.
GA1. Seeking attachment of the award debtor's bank accounts. Full stop. While order dated 22/7/2025, this court directed the attachment of the six bank accounts.
Yes, GA1 came after the order passed. 22nd July was filed pursuant to the main EC. I paid for attachment in the main EC. Okay. Thereafter, I came up with GA1 for additional bank accounts to be attached.
So this is the order of 22nd, right?
22nd July is in the main EC, not in GA1. I'm just clarifying.
All right. So then this
chronologically, 22nd July order was in the main EC. Attached bank accounts of 18 crores. It turned out 13 crores. Thereafter, we filed this GA1 for additional. So to comply with the order, getting the attachment amount up to 18 crores.
Up to 18 crores. Okay. Yes. Okay. Then isko change kar do. The award holder subsequently filed GA1 seeking attachment of the award holder's bank account.
Yes.
Full stop. The no order has been passed as far as GA1 is.
GA1 no order. I'm praying for that.
All right. The award debtor has filed an affidavit of asset. affidavit of assets asserting that it has no administrative or financial authority to effect payment exceeding rupees 1 crore and that it has sought financial assistance from the state government to discharge the awarded liability. Full stop. The affidavit discloses that, comma, apart from the immovable properties enumerated therein, comma, the Public Health Engineering Department under the Gorkha Territorial Administration maintains the following bank accounts on 30th 6 2025. इसमें करना दार्जिलिंग डिवीजन, स्टेट बैंक दार्जिलिंग में बैंक अकाउंट नंबर इज, यहाँ से लो ये पेज 2-1 के बाद इसमें दार्जिलिंग डिवीजन करके 1 फिर नंबर 2 एक्सिस बैंक पेज 3. ऑलराइट, और अमाउंट भी उसमें लिख देना, सो एंड सो अकाउंट नंबर अमाउंट इतना. फिर करो कर्सियोंग डिवीजन सेकंड, उसमें SBI कर्सियोंग 1 एक्सिस बैंक 2. ऑलराइट, फिर पेज नंबर 4 फिर करना कालिम्पोंग डिवीजन, इसमें एक्सिस बैंक कालिम्पोंग नंबर करके उसमें वो डाल देना. These are the attachments.
These are the 4 of the
These are the attachments. All right. It is further contended that that of the 6 accounts attached by this court, comma, only one pertains to the Public Works Department of the award debtor, comma, while the remaining accounts belong to the other departments of the GTA. Full stop. The award debtor submits that owing to the attachment, it is unable to disburse salaries to the employees. Learned counsel for the award debtor. Full stop. Learned counsel for the award debtor further states that the awarded amount has not been paid since the restriction, since any amount beyond 1 crore has to be paid by the state government and they have a financial constraint for making any payment. Full stop. This court is restrained. This court is constrained to record its strong dissatisfaction to the conduct of the award debtor, a public authority, comma, whose repeated laxity and inaction have resulted in a small principal amount of rupees 42,36,863 escalating into a liability of nearly rupees 24 crores, comma, with interest continuing to accrue on a daily basis in terms of the statutory mandate of the MSMED Act 2006. Full stop. The award debtor is a government body and is expected to be fully aware of the consequences of delayed payment under section 15 to 18 of the MSMED Act, comma, which impose stringent, comma, automatic and compulsory interest obligations. Full stop. Yet, comma, despite such statutory clarity, comma, the award debtor allowed the principal dues to remain unpaid for years, comma, permitting the interest component to snowball into an extraordinary high figure of rupees 24 crores. Full stop. The award debtor deliberately abstained from participating in the arbitration proceedings before the Facilitation Council, leading to the ex parte award dated 17/1/2023, full stop. Having suffered the award, due to its non-appearance, leading to the ex parte award dated 17/1/2023, full stop. Having suffered the award, उसके कर दो the award dater further filed AP 763 of 2023, which was dismissed for default, again demonstrating complete disregard towards its statutory and legal obligations, full stop. Despite being fully aware that the interest under the MSMED Act continues to mount relentlessly until actual payment is made, no steps whatsoever were taken by the award debtor to arrest the escalating liability, full stop. Even the conditional order of this court dated 18/12/2023, directing the award debtor to deposit 75% of the awarded amount under Section 19 of the MSMED Act as a precondition for stay was willfully disobeyed, full stop. This continued pattern of indifference has directly contributed to a staggering financial burden on the public exchequer, entirely avoidable had the award debtor acted with minimum diligence and responsibility. This court further notes, with considerable concern, that the affidavit of assets filed by the award debtor is neither complete nor accurate, full stop. Despite this court having attached the bank accounts maintained with the Central Bank of India, account number 321235 30380, Darjeeling, recorded at serial number 5 of the order dated 22/7/2025, the award debtor had chosen not to disclose this account in its affidavit of assets, full stop. This omission amounts to a suppression of material particulars and reflect a serious lack of candor and transparency, wholly unacceptable from a government authority like GTA, full stop. In these circumstances, and having regard to the award debtor's persistent non-compliance, suppression of material facts, and failure to honor either the statutory mandate or the orders of this court, this court directs as follows. In the light of the findings herein above, and having regard to the continued non-compliance and lack of bona fide on the part of the award debtor, the following directions are issued for the execution of the award, full stop. I'll attach that
The additional bank accounts.
all amounts presently lying in the bank accounts of the award debtor in its Darjeeling, Kurseong and Kalimpong division, together with the amount lying in the bank account maintained in the Central Bank of India, bank account number 321235 3038080, Darjeeling, pertaining to the Public Works Department, Public Works Division, shall be forthwith transferred to the award holder's designated bank account, full stop. The award debtor shall be permitted to retain only the bare minimum operational balance strictly necessary for essential functioning of the bank account. Full stop. The managers of the State Bank of India, Darjeeling, Kurseong, and Kalimpong branches and Central Bank of India, Darjeeling, shall immediately effect the transfer of funds as directed above and disclose to this court, and shall file an affidavit disclosing to this court the exact balance lying in each of the said accounts as on the date and time of execution of this order, and confirm the precise amount transferred to the award holder's account pursuant to this order. Full stop. The existing order of attachment over the bank accounts of the award debtor shall remain in full force and operation until further orders. The award debtor is restrained from withdrawing, diverting, or utilizing any amount lying in the attached accounts except as to be permitted by this court. It is further clarified that in case the award debtor fails to take concrete and measurable steps towards liquidation of the remaining liability, this court shall consider directing the immediate transfer of the monies lying in the remaining bank accounts without further reference. Full stop. This court shall also consider issuing consequential orders for attachment and, if necessary, sale of immovable properties of the award debtor as disclosed in the affidavit of asset for satisfaction of the balance amount. Full stop. It is further noted that despite this court summoning the executive engineer,
Public Health Engineering Department.
Executive Engineer, Public Health Department, for appearance on 28 November 2025, he has not made himself available. Let warrant of arrest be issued against the Executive Engineer, Public Health Department, to remain present on the next date of hearing. उसके बाद वो line लिख देना. Requisites shall be done. This is no way. 42 lakhs goes to 24 crores and you're sleeping. Who's paying the money? You're paying the money. Public money being used like this. Shameful. Shall I issue arrest warrant or he'll be here?
Here, Lordship.
Card those को public. The learned counsel for the respondent states that, assures that the executive engineer shall be available on the next date of hearing. Let this matter be listed after 6 weeks. At least do something.
After 6 weeks. One humble prayer, my lord, as to the transfer, I am not saying anything. My lord, as to the additional attachment in para 8 of my affidavit in support of GA1, these are additional bank accounts which are no longer not attached yet. These are additional bank accounts. My lord will kindly be pleased to attach these accounts as well. Paragraph 8 of my application.
Let
Because,
them
my lord,
come, let them.
even the prior order has
They are
been
not
complied.
going anywhere. You know, they have
I appreciate it.
Great.
Yes, yes. My lord, oblige.
at least get something.
My lord, will it be my lord's order? My lord, if the order is uploaded today, we'll take steps itself to the Huh?
And try to resolve the dispute.
We'll remain in
And tell your client he should not get this feeling. Sir,
Yes, I'm sorry, my lord. I'm sorry.
resolve this issue with the
No,
department.
we're always willing. At least if an offer comes, let us consider it. My lord, an offer hasn't even tried. They've not even attempted an offer. Let them at least give us in writing that yes, this is the amount, this is the schedule of payment, something. Nothing has come forward.
This is called unjust enrichment.
But I appreciate, my lord, but my lord will kindly appreciate 2015 last supply. No problem. Deeply obliged, my lord. Deeply obliged. My lord has listed the matter after 6 weeks.
After 6 weeks.
My lord, I'm sorry, my lord. My lord, the interim order that was there till 30th. That's a
The
Sunday.
interim order stands extended
My lord, deeply obliged. Till the
for a
next
period
date
of 8 weeks.
Obliged, my lord. Deeply obliged.
Next. Next.
11. I am appearing for the respondent in this matter. This is a Section 14 application filed by the borrower. Lordship,
Section 14.
14. But Lordship, my point is it is not maintainable.
What is the due jure? What is the ground?
Lordship, the ground
14
is
to
as
it's very clear. If it is not falling within the 7th schedule, it is not maintainable.
yes. Lordship, first of all, they have taken a point of unilateral appointment.
That will not.
Yes.
Mr. Das is sitting here.
Yes.
He has educated this court regarding
Yes. Lordship, it's
Section 14(1).
It's the same point. It's the same point. And I will be referring to that same judgment of Union of India versus.
You will see one judgment at 1 o'clock today also.
Lordship, it's the same point.
Same point.
Yeah.
So nobody is here. What do we do? Dismiss in default or?
Lordship, keep it, Lordship. Once the Lordship's judgment comes, it will be more clearer.
Not today. None appears for the petitioner. In the interest of justice, adverse orders are deferred. Let this matter be listed on Tuesday.
Lordship, please give it.
Yes.
I apologize, my lord.
How is it maintainable?
My lord,
How is it maintainable?
section for my lord
14.
14, my lord, a short password, my lord.
Why?
In some difficulty, my lord, my brief is not working, my lord. A short password, my lord. I'll just.
Okay, you see another judgment coming today. Then
My
we will
lord,
argue on
makes it a short
Tuesday.
password, my lord. I'll just indicate, my lord, what's there. If my lord kindly takes the agreement once, my lord.
You just tell me, does it fall within 7th schedule?
My lord, I'll indicate. I'll
That's
just,
all you need to answer. If it falls within 7th schedule,
my lord.
we'll see it.
If kindly, my lord, appreciates once, your lordship. My lord has seen the agreement once, your lordship. Kindly takes the agreement once. Clause 8, page 34.
Yes.
Now, my lord will kindly take 8.2 and thereafter, my lord, 8.5. The entire procedure of the arbitral proceeding has been already set up, my lord, by the respondents. And subsequently, your lordship will also find that the if 8.2, if your lordship kindly takes any arbitral institution designated as ODR under the provisions of the Arbitration Conciliation Act shall be as updated at the website of the lender from time to time.
So this is the institutional arbitration.
Yes.
But my lord, the entire proceeding is being done by lord, the lender.
This is different.
No, Lordship, I'll satisfy your Lordship.
The entire panel of arbitrators are, my lord, at the behest of the, my lord, lender. So, my lord, my only argument before your lordship, my only contention is that this is entire, my lord, a procedure of unilateral appointment, my lord, of the arbitrator. And moreover, if my lord kindly looks at 8.5, the seat of arbitration for all purposes shall be at Kolkata. Now, my lord, the entire proceeding, my lord, is being conducted from Mumbai.
Lordship, that's a wrong statement. It's an online.
Online, my lord, the
online procedure.
online procedure seat is, my lord, both everything is contradictory, my lord, in this agreement.
And then you file your reply. This is different.
Lordship, I can satisfy your Lordship on the documents itself. If Lordship allows me. I have my documents ready. You have any?
I'll, my lord, I'll reply to whatever my lord senior says.
Lordship, first of all, give me the list of dates, please. List of dates. Lordship, this is a short list of dates that I have prepared, which will be helpful. Lordship, first of all, the agreement itself states that it will be through an online dispute resolution forum, which has been agreed by the parties as they have signed the agreement. There is a consent to it. Lordship, thereafter, on 1st of the arbitrator was appointed from one of the ODRs which are impaneled with the
Yes. Yes, Ms. Tracy.
Yes. Lordship, thereafter, the arbitrator was appointed, Lordship. Where is this copy? Another copy of this. Lordship, this is the procedure through which the arbitrator has been appointed, and there is no function of the respondent herein for the appointment of the arbitrator. Lordship, this is the modality how the arbitrator, I will give you a copy, I don't have it right now. This is the modality how it is, how they are appointed. At the time of impanelment on the panel of arbitrator, a random unique ID is assigned to the arbitrator, capturing the parameters such as area of specialization, experience, and familiarization. The availability of each arbitrator is dynamically updated. At the time of assignment of the dispute, parameters such as nature, complexity, and claim value are captured. Based on the dispute parameters.
Just a minute.
Lordship.
Just a minute. There's appellate side matter today. 12:45 I have kept it. So we'll have it on Tuesday.
My lord.
Or Monday,
Grateful.
whenever you want.
Lordship.
Tuesday, your lordship.
Monday, Tuesday, Lordship, whenever.
My lord. No problem. Monday, it's fine.
Monday? At the request of the parties, that this matter be listed Monday.
Can be done.
For you.
Appellate side.
My lord, the affidavit of service may be kept with the record, your lordship.
Affidavit of service taken on record. Affidavit of
Deeply
service taken on record. Yes. Who's appearing in the contempt?
My lord, I am for the petition. I am appearing virtually, my lord.
Yes.
My lord, this is the contempt application of your lordship order before the circuit bench Jalpaiguri, my lord. The order was passed on 18 July 2025, my lord. My lord, there was a direction to the respondent number 2, the Pradhan, to consider the representation of the petitioner within a period of 6 weeks.
Yes.
From the communicating of this order, we have communicated the order on 19th June 2025.
Have you served the
After that
respondent?
order,
Who appears for the respondent?
but till date, they have not complied that order, my lord.
Now, have you served the respondent? There's nobody on behalf of the respondent. Have you served the respondent, sir?
Yes, my
Has the
lord.
service been effected? Where's the affidavit of service?
My lord, then direction may be given, my lord, once again, my lord, I feel my service.
Somebody has to be here. What is? Where's the affidavit of service? The petitioner has instituted the present contempt petition, alleging willful disobedience on part of the respondents in failing to comply with the order dated 18/6/2025, passed by this court in WPA number 1215 of 2025, titled as Aarti Bala Devi @ Aarti Roy versus State of West Bengal and others. Learned counsel for the petitioner seeks and is granted 2 weeks' time to effect service upon the respondents. Let this matter be listed after 4 weeks.
Grateful, my lord. Yes.
After 4 weeks, give a date. After 6 weeks, kar do na just. 4 weeks time to effect service after 6 weeks. 4 weeks kar do.
Grateful, my lord.
Yes.
Madam,
Appear for the writ petition, my
hearing
lord.
for the respondent number 1.
My lord, this is, my lord, against the Board of Councillors, my lord. Your lordship's order is at page 88, my lord. The relevant portion is at page 93, my lord. Lordship had passed a direction directing the Board of Councillors to pass a reasoned order, my lord. This was against a case of illegal construction, my lord. Till date, they have not done it, my lord.
Have you filed any
And
contempt?
this is the content.
I have not got a copy of
No,
it.
it's only after the, my lord. My lord, may I place, my lord, the relevant paragraph at page 93?
Yes.
Earlier, there was an earlier round of litigation.
Yes, I remember this was.
Yes, my lord. Now, this has also not been complied with, my lord. Paragraph 18 at page 93, my lord.
Yes, madam.
Madam, I'm being led by Mr. Majumdar. He's appearing in this matter. Unfortunately, my lord, he's on his legs.
Well, that's all right, but you have to comply with the order. There's nothing much to contest.
Madam, may I
For the
be
directions, you
granted
have
a
to.
day's adjournment so we can revert to this, my lord? But actually, I'm not briefed in the matter, so I'm not aware. I apologize. I'm not holding the brief.
Or you file your affidavit. The petitioner has instituted the present contempt petition alleging willful disobedience on part of the respondents in failing to comply with the order dated.
Well, order dated 12th June 2025.
2025. Full stop. Learned counsel for the respondent seeks and is granted 4 weeks time to file compliance affidavit. List after 6 weeks.
Grateful.
To comply with the order.
My lord.
Either get it set aside or comply. What is there in the contempt?
Well, the difficulty, my lord, may I just point it out, my lord, because once the order is passed, my lord, then the appeal lies, my lord. So that process is being stalled, my lord. Because illegal construction, if I don't have the order, I cannot proceed, my lord. So
they'll pass it.
Great. Grateful.
We'll shorten the period. Let it be 3 weeks. Compliance affidavit 3 weeks. List after 4 weeks.
List cover.
It's next week, my lord, after you.
After 4 weeks, khatam ho jayega. So 4 weeks for compliance, and then after fifth week, 5 weeks, 9th.
Great.
Supplementary list for judgment, item number 1.
The present petition under section 14 and 15 is not maintainable. The petitioner's recourse is confined to section 13 procedure before the tribunal, and if necessary, a post-award challenge under 34. The prayer for termination of the arbitrator's mandate under 14 and 15 is therefore legally untenable and unsustainable. Hence, the present petition is dismissed as not maintainable.
Deeply obliged.
Deeply obliged.
Grateful.
ये गोपाल ये प्रूफ रीड कर लिया था 28th, huh? Date is 28th, huh? Date क्या है? ये ले. Yes.
Judgment data. Not 2.
My lord, I appear on behalf of the award holder. My lord, the judgment debtors have surrendered before the honorable court.
Lawyer नहीं है आपका कोई? Just ask him.
Lordship, I am appearing. Lordship.
Yes.
Lordship, after getting the order, Lordship, of the Honorable Justice Shompa Sarkar, Lordship, Lordship, kindly warrant be stayed, Lordship. I shall appear on the date in the December monthly list. The matter is fixed, Lordship, and after that I shall appear and take steps accordingly, Lordship.
No, but today you are appearing for whom in this?
For Sheikh Rajesh and Alauddin, Lordship.
Both the judgment debtors, my lord.
So Rajesh is here, right?
Rajesh.
And Alauddin both are here.
Both are here, Lordship.
So warrant is executed. We'll discharge it.
Yes, Lordship.
My lord, may there be direction upon
Yes,
them for the
affidavit of asset will be filed. Just give the oath.
আমার নাম শেখ রাজেশ
শেখ রাজেশ বাবার নাম
বাবার নাম শেখ আব্দুল
শেখ আব্দুল বেঁচে আছেন
না ইন্তেকাল করে দিয়েছে
শেখ আব্দুল আপনার বয়স কত
আমার বয়স 30+।
30 আপনার বাড়ির ঠিকানা
জয়দেব ইলাম বাজার বীরভূম
জয়দেব ইলাম বাজার বীরভূম কোন ডিস্ট্রিক্ট
বীরভূম ডিস্ট্রিক্ট
আপনার কি করেন আপনি
আমি মাঠে ঘাটে কাজ করি গ্রামে থাকি
কি কাজটা করেন কাল্টিভেশন আপনাকে যেদিনকে জজকে আসতে বলবে সেদিনকে আসবেন বুঝছেন আপনার উকিল কাছে একটা ফর্ম আছে তাতে আপনার খবর সম্পত্তি যা আছে যেটুকু আছে সেটুকু লিখবেন লিখে জমা দেবেন আর আপনি যদি না মানেন তাহলে জজ সাহেব আপনার বিরুদ্ধে আছে
ঠিক আছে
নেক্সট যা বলবো সত্য বলবো সত্য মিথ্যা বলবো
যা বলবো সত্য বলবো সত্য ছাড়া মিথ্যা বলবো না
কি নাম আপনার
এসকে আলিমউদ্দিন
এস আলিমুদ্দিন এসকে আলিমুদ্দিন বাবার নাম
এসকে আব্দুল
বেঁচে আছেন
না
লেখ এসকে আব্দুল শেখ আব্দুল আপনার বয়স
আমার বয়স 28
28 ইয়ার বাড়ির ঠিকানা
বাড়ির ঠিকানা জয়দেব
জয়দেব পুরোটা বলুন
জয়দেব জেলা বীরভূম
ডিস্ট্রিক্ট বীরভূম ইলামবাজার
ইলামবাজার
আপনি কি করেন
আমি লেবার কাজ করি
লেবার ডেইলি লেবার আপনাকে যেদিনকে জজ সাহেব আসতে বলবেন সেদিনকে আসবেন আপনার যে উকিল আছে ওদের কাছে একটা ফর্ম আছে ওই ফর্মে আপনার কি সম্পত্তি আছে স্থাবর অস্থাবর যা সম্পত্তি আছে জমি ফমি যা আছে ওদের পড়বেন ওদের জমা দেবেন ঠিক আছে আপনি যদি এগুলো না করেন তাহলে জজ সাহেব আপনার এগেইনস্টে ঠিক আছে
Awarded number 1, Sheikh Rajesh, and awarded number 2, SK Alimuddin, are present in the court. Oath has been administered. Full stop. The learned counsel for the awarded number 1 and 2, as well as the awarded, undertakes to file their affidavit of asset and further undertake to remain present in the court for examination as well as any other proceeding. Full stop. Warrant of arrest is discharged. That formatted was for them. Within a period of affidavit of asset, 2 weeks?
2 weeks.
Within 2 weeks.
Grateful.
4 weeks? After 4 weeks? After vacation. After vacation.
I'm appearing for the judgment debtor, my lord.
Yes.
Seeking to pay the warrant by the my lord. This is an award passed by unilaterally by the arbitrator, my lord.
Give the oath. How many people are there? One.
বাংলা বাংলা বলিস যে ধর্মকে বলবো কি যা বলবো তো যা বলবো সত্য বলবো কি নাম আপনার মিলন কাঁড়া মিলন কাঁড়া কাঁড়া কে আরে কে আরে এ আরে কাঁড়া বাবার নাম মধুসূদন কাঁড়া বেঁচে আছে মধুসূদন কাঁড়া তার বয়স
Lordship, an outstanding of 17 lakh 70,000 as on 23.
বাড়ির ঠিকানা 121 বৃন্দাবন মল্লিক লেন বৃন্দাবন মল্লিক লেন কলকাতা না হাওড়া হাওড়া কত হাওড়া 71104 71104 কি করেন আপনি আমার ব্যবসা ছিল এখন কি করেন বর্তমানে কিছু করি না আমি আনএমপ্লয়েড আপনাকে যেটা দরকার বলতে যে আপনি আসবেন ডেটে বলবেন আপনার কাছে একটা ফর্ম আছে ওই ফর্মে আপনার খাবার অবস্থা সম্পত্তি আছে যেটুকু আছে সেটা বলবেন ঠিক আছে এগুলো যদি না পারেন জজ সাহেব আপনাকে আপনার কাছে তিনটে নাম তো হবে অত তারা
Affidavit asset within 2 weeks. Same order.
জানি না স্যার
अगली बार जेल भेजेंगे
পরের বার যদি
पेमेंट करना होगा
টাকা না
tell him to make the payment he looks so happy without making the payment
অসুস্থ তো একটু টাইম লাগে
tell your client shouldn't be so happy standing in the box he'll not come here to in a park
He's sick, my lord, and cerebral attack was happening.
ask him to settle it next
I don't have food.
Oh, my lord, I'll be appealing on behalf of the spot.
কি নাম আপনার
नंदू चौधरी नंदू चौधरी
नंदू चौधरी बाबार नाम
लेट गौरी शंकर चौधरी
लेट गौरी शंकर चौधरी उम्र आपका 43 आपका घर का पता
6B गोहरला स्ट्रीट
वाला
हाँ GOUR गोहरला गोहरला स्ट्रीट कलकत्ता 7,06,000
कोलकाता 7,06,000 और क्या करते हैं आप
मेरा बिजनेस था लेकिन
अभी क्या करते हैं
अभी मेरा जैसे रिटेलर का काम करते हैं दलाली का काम लकड़ी का
आपको जिस दिन जज साहब बोलिएगा उस दिन आइएगा
हाँ जरूर सर जरूर सर
और आपका वकील के पास एक फॉर्म होगा उसमें आपका जो संपत्ति है उसका पूरा बयान दीजिएगा ठीक है ना ये अगर नहीं कीजिएगा तो जज साहब सीधा ही जेल में
नहीं सर हम दे
क्या पैसे दीजिएगा
सर हमको थोड़ा सा वक्त दे दिए मैं दे दूंगा सर पैसा
चलिए 2 हफ्ते में आप पहले एफिडेविट ऑफ एसेट फाइल करिए उसको सेटल करिए 2 हफ्ते में
ठीक है सर
29 lakhs, Lordship.
ठीक है सर
2 हफ्ते में
There was a settlement arrived at, part payment he did, but thereafter he failed.
try to settle it finish it.
My lord, I have spoken to him and
within 2 weeks file your affidavit of asset
my lord gives me 3 weeks, I'll file my affidavit.
2 weeks it's your asset you know where the asset is
My lord,
within 2 weeks
my lord's keeping it after the vacation.
after vacation
Much obliged, Your Lordship.
Mr. Banerjee which matter
I was thinking, Lordship will come back to the normal list
Grateful. Mr. Mukherjee and I was discussing this only outside. So we were just thinking, is it good for the day?
Which matter?
My lord, it's there in the list.
Normal, the normal list. So it's, since it is good for the day, we can also proceed.
My lord, next week.
We'll do it. Great.